Thank you very much. Thank you. So yes, my title is quite sort of grand. I say I'm talking about law and lordship. Well, the bad news is this is mainly law, because law is what I work on largely. But lordship does come into it, because that's the whole point. Without any martial lords, you wouldn't have any martial law. So that's one of the things I'm going to be looking at. So what I'm going to be looking at largely is the law of the march, and I'll give a very brief guide to what it was, and more importantly, perhaps what it wasn't. And I'm going to give some examples of the way it was used and abused in the March of Wales. Now, I'm sharing, this is Philip's map, although I don't think Philip used this in his talk, but Philip has several. I very much approve of Philip's map without the boundaries, actually. There's a lot to be said for that. So, in fact, this morning has been extremely useful, because Philip gave an excellent introduction to the march, what it was, how it came about, which means I don't have to do the same. So I can focus more on the law, which some of you might be filled with horror at that. But that's what I'm going to do. So what I'm going to do is flip away from the map of the march, as you're all no doubt familiar with sort of the layout and how it works and that kind of thing, and have a quick look, a very brief introduction to Cyfraith Hywel, which is medieval Welsh law, which was medieval Welsh law. So in England, there was, and still is to some extent, the common law, as we know. Wales, throughout the Middle Ages, had its own system, Cyfraith Hywel, known as Cyfraith Hywel, the law of Hywel, attributed to King Hywel Dda, Hywel ap Cadell, who died in the year 950. So the laws that are attributed to him. Now, the background to Cyfraith Hywel is a very long and complex thing. So what I'm going to do here is just focus on the main points that I'm going to be talking about. So some of the things that you need to know. I'm happy to go into great detail on Cyfraith Hywel at another point, or indeed, well, briefly in questions. But for now, just a quick sort of overview of what it is. This is a very brief summary. So medieval Wales had its own law. It was different to English law, also different to canon law, the law of the church. It was a special sort of law for medieval Wales, and it was in operation throughout the Middle Ages up until the conquest of Wales in 1282. Now, notice I've said it's a written law, it's codified, as in it was written into books of law. There's two examples there on the screen for you. Very lengthy books, really thick books of law, assuming to contain the whole of the law of Wales. It's a civil code, okay, so written books of law, and that's different to what was going on in England. The common law doesn't work in that way. Now, I mentioned that Wales was conquered in 1282, but the manuscripts of Welsh law date from the mid-13th century right up to the 15th century. Now, there are no manuscripts of anything in Welsh. There are no Welsh manuscripts before 1250. 1250 is the magic date when Welsh manuscripts suddenly start to survive, if not be made. The earliest manuscripts of Welsh law do date from 1250, so they're among the earliest manuscripts of anything in Middle Welsh. But the manuscripts continue to be produced, and there are manuscripts still being produced right up to the start of the 15th century. Now, that's interesting because I just pointed out that Wales was conquered in 1282, but the law didn't come to an end, and it continued to be in use in several regions, not necessarily in North Wales, although it did actually. The conquered territories were allowed to continue using Welsh law in anything except criminal matters. For criminal matters, they were supposed to adopt English law, but the Welsh law continued in all of the other areas, including the March. And Welsh law, there's a lot of evidence of survival of Welsh law in the March. Several of the later manuscripts, the post-Conquest manuscripts of Welsh law, have a distinctly Marcher flavour. This is something I work a lot on. It's a long story, but they have a very Marcher flavour. And several of the later manuscripts of Cyfraith Hywel could be called Marcher texts. So a very brief introduction to Welsh law, but that's a sort of need to know kind of thing for the rest of the paper. Because what I want to talk about, of course, we know that in the Middle Ages, we've got England, we've got Wales, but there's the bit in the middle, the good bit, the March, and it had its own law. Now, Magna Carta refers to, in clause 56, my favourite clause of Magna Carta, it refers to disputes regarding lands in Wales and England and other places, you know, 1215. And Magna Carta states, if a dispute arises about this landholding, then it is to be dealt with on the march by the judgment of their peers. For English tenements, according to the law of England, for Welsh tenements, according to the law of Wales, for tenements in the march, according to the law of the march. Now I've got a very blurry picture of Magna Carta. What I wanted to do was have the words, the law of the march, up on this screen, you know, huge lettering. Unfortunately, they occur at the end of a line at the start of another one, so I just couldn't do it because Magna Carta's lines are too long. So according to Magna Carta, the law of the march is a third system of law, which is interesting, but it's not as straightforward as all that. Nothing ever is when we look at the march. Now, the law of the march was studied in detail by Professor Rhys Davies, Professor Sir Rhys Davies, actually. Now, David Stevenson referred to Professor Rhys Davies, who was his doctoral supervisor. He supervised my master's. So Rhys Davies has his hand here today. Now, Rhys Davies in 1970 published a very important journal article looking at the law of the march, and he called it, very imaginatively, the law of the march. Very groundbreaking. It was a lengthy study starting from that reference in Magna Carta and examining the law of the march as a distinct system of law, which is what Magna Carta implies, but distinct to both English law and Welsh law. Now, at the start of his article, he states that his findings will be tentative and speculative because of the problem of evidence. But what Rhys Davies did in the article was he went on to form an excellent overview of the evidence base for the law of the march, looking at court rolls, surveys, charters, and important collections, such as those in British Library manuscript 46846. That's a specific manuscript discussing marcher customs. Now, returning to a point made by David, in fact, David, in many ways, has stolen my thunder this morning, although David always steals my thunder, and I am David Stevenson's #1 member of his fan club. But David this morning pointed out that several eminent Welsh historians quite often look at the march from within the march, if you like, and that's exactly what I was going to say. Rhys Davies does the same thing, and Rhys Davies was an eminent Welsh historian, but his tendency was to look at evidence for the law of the march in the march itself. I'm doing something slightly different. Again, those of you who went out for a cup of tea when David was giving his talk will think that this is all very groundbreaking, but actually David has already said exactly what I'm going to say, that the tendency is to look at things like the law of the march in general, from within the march. But there's a lot to be said for looking at it from the outside, from the Welsh perspective, and looking in, which is what I'm going to be doing. Now, in his sort of article, Rhys Davies examined the customs and the borrowings from Welsh law into the march, but he also looked at the feudal aspect to the law of the march. He states that marcher law is the might have been of English history. It shows what could have happened to private jurisdiction in England had the common law not developed and stepped in to deal with it. He states that, I'm quoting Rhys Davies quite a lot this morning. He states that the custom of the march were united by the fact that they were consciously contrasted with the customs of the realms of England. So this is not just English law. There may be Welsh law too, but it's not just English law, and that's the point. Magna Carta can refer to the law of the march because it's not just English law that's in operation there. And he points out that the law of the march had many elements which were distinct from Welsh law as well as distinct from English law. To justify that statement, not that Rhys Davies needed to do so, but that statement in Magna Carta can be justified because this is not just English law and it's not just Welsh law either. There's a combination of things going on. But he notes, and that's the final quote I have for now, that lack of originality is one of the hallmarks of marcher law, in that this is a legal system that borrows from both sides. So it was a seminal paper. There's very little that has been written since which can supersede these conclusions, and I'm not going to do that either. So I'm not intending to deviate or disagree with this article, no cause of argument with what's said, and the content still stands. But what I am going to do is take a different give a bit of an overview of how things worked in the March, but from a different standpoint. From the standpoint of Welsh law, which is my own background, and which is what I know about. So like David, I'm going to be looking at martial law, but from the Welsh side of things, if you like. My starting point is going to be Welsh law, Cyfraith Hywel, and how Welsh law was worked in the March, but also why it was worked in the March. And I'm going to be using law as a source for society and for lordship. So what I'm going to be doing is giving some sort of case studies, if you like, to show how these things could be worked. Now, referring back to Philip's paper, Philip discussed that the March was often seen to be a corrupt and lawless place. Sort of anything goes, a total lack of control. You know, it was viewed with suspicion from England largely. It was famous for being a sort of gathering point, if you can have such a thing, for outlaws. People were abducted there. They weren't answerable to English justice. There's stories of raiding, cattle raiding specifically over the border, again into England largely, burning, looting and killing, you know, complete and utter chaos. Now, and I've got a picture of Robin Hood, but it could equally be Fulk Fitzwarren, who was a Marcher legendary figure, very similar to Robin Hood. In fact, Robin Hood may well be based on him. But that sort of total lack of control, lack of well, lawlessness in the March of Wales. It's how it's often known and often referred to in the Middle Ages as being some out of control borderland. But it wasn't the case necessarily, because in the March you did have an acknowledged legal system. There were acknowledged customs anyway. There were ways of doing things. What you have in the March is a combination of very different laws. You've got two legal systems being combined, at least two legal systems being combined. And from the outside, this might have looked odd or difficult or even unworkable. And I think this contributes to the bad reputation, this sort of reputation of lawlessness in the March. It's a lack of understanding. It's that classic thing where not being able to understand a different system, a different culture, a different judicial system or different legal culture leads to perhaps the easiest thing to do is to condemn it. And you see it throughout the Middle Ages. This is something that does happen. But if you're from the English standpoint with your allegedly superior laws, looking at the March with this mishmash of customs and lack of order, seeming lack of order, then of course, you know, criticism is one good option. Well, it doesn't, you know, how does that work? It doesn't work. There we go. So that's, I would say that's largely why it's been condemned to a great extent. But what you do have is there is a semblance of order there. There is order in the March. The Marcher lords had power to create law in their own lordships. They had regalian rights. They were, you know, kings in their own domains. And also on a practical level, the Marcher lords needed to run their lordship and maintain control over the people that they were ruling. So how do you do that? Well, you get a system of law, any kind of system, preferably one that works. But making a legal system from scratch was unnecessary, and it's also, I would imagine, rather a lot of work. So the Marcher lords had at least two sources they could draw upon, and I'm only looking at English law and Welsh law here. They also had canon law, the church law, to draw upon. Also European legal systems such as laws from Normandy, etc. But focusing on England and Wales, they had at least two systems that they could draw upon, and they did draw upon both legal systems. So what I want to look at is what kind of things would be borrowed, or what kind of things were borrowed, and why were they borrowed? And I think this can tell us a great deal about what was going on there. So before I look at some case studies of the things that are being borrowed, a summary of the law of the March. The main thing I think we need to remember is that this was not a written law. It's not an organised corpus of law. So Magna Carta's reference to the law of the March implies that it's something fixed and formal. It wasn't. It would vary according to the lordship. It would vary according to time period, very much like the March itself. This was adaptable, flexible and ever changing. But it wasn't, you will not find a book of Marcher law that says exactly what the whole of the Marcher law for the whole of the March was, because that kind of thing did not exist. On the whole, it's combined elements, the legal system or the legal customs in use combined elements from both Welsh and from English law. And its heyday was the 14th century, according to Rhys Davies. I would agree, although I'd also go into the 15th century, but as David says, not enough has been done on the march in the 15th century. But one big quotation, not from the Law of the March, from another study by Rhys Davies, is that the complexity of the Law of the March lay in the fact that it was a plural law, drawing on two, at least, legal traditions and catering for two peoples. It was a mixed law for a mixed population, administered often in different courts, English and Welsh, within the same lordship sometimes, and often served by different officers and different procedures. That's a very important quotation, which I'll be returning to on a regular basis. I'll be saying the same thing over and over indeed. One important point, he discusses procedures, is that the Law of the March, in terms of procedure, followed largely English law. So English law at the time had established procedures, organised procedures, established ways of doing things. The Welsh law texts are rather silent on procedure. So in many ways, it was easier to follow the sort of working methods of English law in the March than it would have been to follow the Welsh ones. Although, I mean, I say it's an easy borrow, we don't know enough about Welsh procedure. The law texts are silent on that. So perhaps I'm arguing rather into a void here, but we do have evidence for how things were done in the March, and it was largely done following English procedure. For example, there were writs. Writs were used in the March of Courts. There's an example of a writ there. They weren't the king's writs, but they were writs all the same. So the same framework for operating the law seems to have been adopted from England. The same framework as in England was adopted in the March. The content, however, of the law was mixed, what we can gather from the contents, despite this not being a written law, and it drew on both traditions. Now, I'm going to discuss why we draw on both traditions in a moment, but as with procedure, largely drawing on English law, the content of the martial law would often lean quite heavily on Welsh law, because Welsh law was a written law, again, so an easy borrow that way. But there were often specific reasons for the way things were combined in the March. Now, the lords usually in fact, had lands in England as well as in the March, so they could have just used the whole of English law, carry it over as it was, but they didn't do this. Welsh law was borrowed too. And why borrow Welsh law? So to answer this question, why was this mixture sort of adopted? I'm going to consider the types of things that were borrowed, or some types of things that were borrowed, to discuss that. So for example, you have some institutions in Welsh law which were not there, which didn't exist in English law, and vice versa. And the reasons behind the way the lords selected the laws, the ways they went about picking and choosing, that's what I want to look at today. So I'm going to look at 3 case studies demonstrating different reasons for the blending of laws, although it all often boils down to the same point. So my first example is going to be criminal law. I'll put this up so that you can have a quick read of this. Now, one reason for using different laws currently, mixing and blending, rather than taking an entire legal system in its entirety, was to do with conquest. The different laws in operation were there because there were different people mixing. Back to Rhys Davies's quotes of, different populations, different laws, different needs. Often, rather than upset things or completely rock the boat, it was useful for the martial laws to let the Welsh have something familiar, and the English likewise. Let people have what they know. If you are taking over a territory and you've got different people, let everybody have something familiar and it feels less painful, I guess. This was the administration of territories with mixed populations, as Rhys Davies's quotes said. And so keeping people happy was fairly important, not changing everything overnight. This is not the Norman conquest we're talking about, not changing everything overnight. And one reason for not changing everything dramatically overnight and imposing new things on people is to keep people happy, because if people are generally happy and aren't horrified by changes that are being forced upon them, then they're less likely to complain, they're less likely to rebel. So it's a way of keeping order, and it's also convenient in many ways to keep things as they are. And one example is criminal law and homicide. Now, a word about homicide in Welsh law, or in fact in general. Their criminal law is not a very developed concept in Welsh law. It's a modern concept, and using the word criminal law to apply it to the Welsh laws doesn't really work, because the Welsh laws, Cyfraith Hywel, is not a moral code. There is no element of punishment in Cyfraith Hywel, as in there is no execution for killing another man. There is execution for theft in certain extreme cases, but theft is a crime against society, and the tendency anyway was to avoid execution for theft. Now that's quite a big say, and you're all probably thinking, how on earth did anything work then? Well, it's not a moral code. There is no punishment. The main driver in Welsh law is compensation and keeping society running smoothly. And the reason there is no punishment in this way is because of the way society and politics worked in Wales. The law needed to function whether or not there was a strong ruler at the head. This is not a top-down, state-sanctioned law. Now, Philip discussed how the politics of Wales was ever-changing. You'd have, kingdoms would change shape, kingdoms would be taken over by other rulers, etc., etc. It wasn't a stable situation. England, on paper at least, had a strong ruler, and the King of England was the head of the law. He was the ultimate dispenser of justice, well, other than God, and he was also a figurehead, but the law was in the name of the king. It still is today. But in Wales, this was not the case. Keeping society running was the main thing, so things needed to be resolved on a local level. Incidentally, the English system gives the king immense power because the king is in charge of all of justice. And for a marcher lord, the English criminal setup gave the lord more power, so it was often favoured. This is for power and control reasons. But it's clear that there were some Welsh options adopted too, and Welsh practices such as galanas were known as well. Now, galanas is on the screen there for you. Galanas is the word for homicide in Welsh law. It's also the word for the fine for homicide. In modern Welsh, incidentally, is the word for a big mess, which is interesting in itself. Now, galanas worked on the basis, it's very similar to wergeld. Every person had a life value, and if that person was killed, then that life value had to be paid if it was by the actions of another person. And the idea was that the entire extended family, up to the fifth cousin of the killed man, would receive a share of his wergeld, or his galanas payment, from the entire family of the man who had killed him, again, right up to the fifth cousin. And it goes in a sliding scale. That pyramid shows how it works. Everybody gets, the homicide pays the most. He pays a third of the life value, and everybody else pays a share. And the idea is to prevent blood feud and keep society running smoothly, so that you don't get revenge killings from distant cousins, avenging the death of another distant relative. So is the main driver there. And you see references to this system being used in the March as well. English law might have been the first choice, but also galanas was known. And Davis says that in the March, the felon, and this is not just in homicide cases, the felon could often avail himself of the custom that, having satisfied the appeller, he could also buy off the suit of the lord and thereby secure his life and limbs, and often his goods and chattels. So somebody who'd been accused of a crime could actually buy his way out of it. Now, I mentioned that there was execution for theft in medieval Welsh law, but the tendency was to try and avoid executing people if necessary, but theft was a serious crime. And the Welsh texts say, and this is on the screen for you, however great the theft alleged against him, against the thief, it is not right for his life to be forfeit if he can pay £7. And another section says, whoever catches a thief with a stolen property in his hand and releases him, whether for kinship or for value, if he admits it, let him pay £7. For though the thief's life would be forfeit, law does not judge his life to be forfeit if he can pay the £7. Now, redemption vitae is something, so saving of life, basically, is something that was in use in the March, and Rhys Davies refers to this. And this is clearly loosely based on the Welsh practice of a thief being able to buy himself out of execution. And the interesting thing for me is that the sum that Rhys Davies names in Caws, it varied in other places, it would depend on the nature of, the amount of damage or whatever that had been done. But in Clun and Caws, the price for redemption vitae that a person would have was fixed, and it was fixed at £7, which is exactly the same price as that of a sale thief in Welsh law. So that's more than a coincidence, I would say. Now, the big advantage of using things such as this is for reasons of popularity, flexibility, but also the Lord could show that he was willing to show mercy, show he was not barbaric. And it's also useful for exploitation as well, because this money, this £7, would immediately go to the Lord himself. So my second example is following on from the concept of the Lord and his image, how he wanted to be portrayed, and how law could be exploited to do this is land law. Now, Welsh law, this is Rhys Davies again, especially land law and civil law, too closely intertwined with the structure and customs of society for it to be dismantled or eradicated by seigneurial edict. Welsh land law is very, very complex. People couldn't buy and sell land. Very different setup to that in English law. So generally, Welsh law would continue, except for some cases, and there's two examples there, where you've got a Welsh action that could be replaced loosely by an English one. But you also get a combination of factors. Now, this is a reference to Dadl Croes. It's called the cross case. And what it is a procedure for claiming land, description of a procedure for claiming land using a cross. I'll explain that in a second. In the hand of Hywel Dafydd, who was a Welsh poet, and he was also steward of Tretower and very much a marcher figure. And he describes the procedure for claiming land. It's not an actual case. Very similar to the Deddfau Powys that David Stevenson referred to earlier on. But these are Welsh documents of marcher law, explaining marcher law. Now, the case might be limited to Brycheiniog, but it's very important evidence. And this is the opening section of it. You claim land that somebody else has been using. And what you do is you get a cross, an actual cross, and stick it in the land, and then you start your legal process. And then the other person is sort of summoned to law. And this is a very long, drawn out situation. This, the defendant can refuse to come to court up to 12 times or more. He can just refuse to come. An esoin is an English practice, an excuse for not coming to court. And you can sort of make several of these esoins and not come to court, and you come up to the 12th court. And this sort of gives you immense delays. Now, delays can be very beneficial. And land law was famous for its delays, but also Welsh law was famous for its delays. And this case is the most long drawn out thing you'll ever see, I would imagine. It's incredible. But they're making use of delays to benefit people. And the options, it's a very mixed case. The options to end the case is very mixed. You've got memory, judgment, or 12. Memory is from Welsh law, where you call on people to remember what the situation was. Judgment is both systems, and 12 is the jury. So it's a very mixed case. But land law could be used to, here's an early example, not from the March, of the English Crown exploiting land law for power and control. The tenants of North Wales had to follow Welsh law for landholding, but Welsh law divided the land over and over again until you had a pocket handkerchief and couldn't leave your father's house. You're a beggar living with your parents. And so they ask, please could they have leave? In 1320, they asked Edward III, please could they have leave to sell their lands because they want to sort of have the benefits of English law. But the king's answer is no, they can stick with Welsh law because poor people don't rebel in the same way. So it's not just marcher lords that were exploiting law. And for the last couple of minutes, a very quick discussion. Now, this is something that I'm discussing in the next issue of Mortimer Matters. But there are some elements of the laws that could create an income to the Lord. Fines could go to the Lord. This is useful. And so law could be exploited for this. And what I want to discuss briefly is amobr. It's a fine for virginity. It's a payment for virginity that was part of the wedding payments, marriage payments in medieval Welsh law. And there's examples of it. So the amobr was paid by the person giving the woman, but it was sort of steps were taken to make sure that this amobr payment for virginity was made, was collected, whatever the situation of the union. Now, this all comes from the idea of the Lord as protector of all the young women in his kingdom. I'll probably the origin of the payments, early link between kingship and fertility. This was a very early concept, but it lasted for a very long time. It's listed amongst, in a 15th century manuscript, amongst the ways a lord could be entitled to his man's goods lawfully. There's amobr. The different Clwyd court rolls regularly refer to amobr, but also to the amobrydd, the amobr collector. There was a man whose job it was to collect this virginity payment. And it paid well, as you can see on the PowerPoint. But for some lords, this wasn't enough. In Bromfield, in 1336, the martial lords, now I think it's fairly obvious that a virginity payment can only be claimed once, but in Bromfield in 1336, it clearly was not the law, becoming financially crippling for some women's families. It's recorded that particularly sociable women were given white rods as a symbol of them being prostitutes, so that their kinfolk would not henceforth be troubled for amobr, because they were claiming amobr every time a woman coupled with a new man, shall we say. So it was claimed over and it was crippling for the families. So that's an example of profiteering from law. So my conclusion, very quickly, is that in the Law of the March, Rhys Davies gave a good picture of martial law as practiced in the March of Wales. But looking at some case studies, some of the aspects of Welsh law which were borrowed, and more importantly, how and why these aspects were borrowed, can tell us a great deal about the nature of society in the March of Wales. And it can reveal even more about the power of the martial lords and their control over their mixed society, the way they could use law to reinforce and indeed bolster this control that they had. Thank you very much.